Welcome to the Meaningful Mediation Podcast, the place where leading lawyers and negotiators share their best tips and strategies for mediation and negotiation. I'm your host, Patrick Russell, a full-time Florida mediator and lawyer. My goal is to help you have an effective and meaningful mediation. Each episode will provide you with real-world strategies and tips to help you negotiate and mediate with confidence. Let's get to it. All right, very good. Well, welcome back to the Meaningful Mediation Podcast. This is the show where we talk with lawyers, mediators, and negotiators who spend their careers doing the hard work of resolving legal disputes. I'm your host, Patrick Russell, and today I'm really looking forward to this conversation. My guest is Kelly Fantetti. Kelly is an attorney with Stockham Law Group right here locally in Tampa, Florida, where she represents homeowners, business owners, and condominium associations whose property insurance claims have either been denied or underpaid. We've got wind, water, sinkhole, fire, flood, construction defects, a whole full litany of anything that can go wrong with property. She's admitted in Florida, Michigan, and Texas, and has been recognized by super lawyers for insurance coverage. And she's also actively involved with the Windstorm Insurance Network, a place where policyholders and defense lawyers actually sit in the same room and try to make the industry work better. Kelly, welcome to the show.
Thank you. Thank you for having me.
My pleasure. Well, let's start off with something that I think is really kind of fun at the beginning for everybody to kind of get a feel for the lawyer behind the cases. So
Okay.
let's start with kind of how you ended up doing this kind of work. So how about we start with, I think, listeners who don't live inside the Florida property insurance world, this is a good opening question for you. We all know that Florida has recently overhauled this area of law, probably more than once in the last few years, right?
Yes.
And we're talking about assignment of benefits changes, the one-way attorney fee rollback. So from your seat, what has been the net effect of some of these recent changes?
Well, do you want me to talk about how I got into the industry, or do you want me to talk about the changes in the litigation first?
Let's start with the industry.
Okay. When I'm from Michigan originally, and I moved to Florida after law school because my husband had a job here. And I was working at the 12th Judicial Circuit in Bradenton, and I was court counsel for all the judges in Bradenton, Sarasota, DeSoto counties. And I got a call. Well, one of the judges came to me and said that he had gotten a call from an insurance defense firm who was looking to hire a young female associate. At that time, I was doing mostly criminal work, handling post-conviction motions, things like that. And so I had no idea what first-party property was, and it was not a big thing when I was in law school in Michigan. But I took the meeting and ended up doing insurance defense work after that for several years. And then after Hurricane Irma hit, I got recruited to flip sides and start doing work for the policyholders. So that's how I got into the industry. At one point, I did try to switch over to doing more liability work, auto accidents, slip and falls, personal injury type stuff. And I had been doing first party property for so long that it just didn't make sense to my brain anymore. How do you value a brain injury? How do you value an arm, a back surgery? I understand getting bids and putting prices on roof and plumbing and windows and those that my brain could compute very easily, but the personal injury stuff just didn't make sense to me anymore. So the house stuff isn't glamorous, but I love it now, and I feel like I've gotten very good at this one specific area of law. So the better you get at it, the more fun it gets because you can make it work for your clients when you really understand it.
Yeah, well, there's something to say for having a niche, right?
Yeah, exactly.
Not being the jack of all trades because you could be the go-to expert in your particular area.
Yeah, but
So,
as you
okay.
mentioned, it has changed a lot over the last 10 plus years that I've been doing this area of law. That it does change the leverage you have in dealing with the insurance company and being able to push a resolution that works for your client. The attorney's fees, they originally passed the notice of intent to litigate law, which required you to make a pre-suit demand before you can file your lawsuit. And the plaintiff's attorneys kind of poo-pooed that. Nobody loved it, but it wasn't that big of a deal. It did make sense to have to send that demand ahead of time. You have to do that in a lot of other areas of the law. And that created a fee shifting mechanism. So if you went to a trial and didn't end up doing better than, or at least as good of what your pre-suit offer was compared to their pre-suit offer, there might not be any entitlement to attorney's fees. And that was a significant risk for your client, because any attorney's fees that aren't recovered from the insurance company come out of their award. So it made sense to the client to do a lower pre-suit demand to try to get it resolved. And I found that we were getting a lot of stuff resolved pre-suit during that, 1 to 2 year phase where that statute was in place. But then in December of 2022, they just did away with attorney's fees altogether. And in the last 3 years since that's been gone, it's made it a lot harder to get cases resolved, not only pre-suit, but in suit. I'm seeing a lot more stuff going to trial, and it gets a lot more expensive on both sides.
All right. So was there something that legislature actually got right with all these changes or not, in your mind?
I mean, I think that their intent, in theory, was in the right place. They were trying to reduce premiums for homeowners and increase availability of insurance options and competition in the state, which, is always a good thing. But I think what they failed to realize is that the availability of insurance is useless. It's useless to have insurance that doesn't pay out on claims. So you have a homeowner that's still paying exorbitant premiums because they made all of these changes to the litigation process. They eliminated attorney's fees, but they didn't require there to be any tie to reduced premiums. And so we didn't see premiums go down. I think most homeowners are still seeing their premiums go up, even though the litigation has fallen off. And the reason that the litigation has fallen off so much is because attorneys can no longer take on claims for homeowners that have $10,000, $15,000 in damages. If I'm taking a contingency fee percentage of your damages and fronting all of the costs on your claim, by the time we get to a trial, that whole amount is being eaten up in fees and costs. I just cannot run a business in a way where I can help those types of homeowners. And those homeowners with the small claims are the ones that need us the most, and they're the ones that we can't help anymore because of this litigation. And I think that the legislature didn't take that into account at all when they were passing these bills.
Yeah, that's an unfortunate, I guess, unintended, we would hope, consequence of what's happened. The smaller claims are probably hit the hardest.
Yeah.
Pivoting over to your work with condominium and community association, that's a whole different animal than a homeowner.
It
where-
is, but they've been similarly hit hard with recent rounds of litigation in the last couple of years, because the condo associations have also seen their insurance rates skyrocket. But in addition to the skyrocketing insurance rates, now they are also facing, because of the Surfside collapse, they had all of those inspection requirements. Now they have to fully fund their reserves. They have to do engineering inspections every so many years. They have to be keeping up with all of these requirements. I'm not saying those things are a bad thing, but the problem is that all of those financial obligations hit at the same time. And what you're seeing now is an elderly population that can't afford to own a condominium in the state of Florida anymore, because between, the assessments and the insurance premiums are so high as to make it unaffordable. And a lot of those units are also unsellable right now. And so I think it's really the condominium market in Florida has been really impacted a lot by all of these factors combined.
I recently saw a news source where they listed, I think it was 54% of all condominiums in Florida are still not compliant when they were supposed to be.
Yeah.
That's a pretty staggering number. And then they indicated, there was one here down in South Florida where the assessment, gather this, was $400,000 per unit.
Yeah.
Where are people going to come up with that, nice Christmas present?
And people think, oh, well, you just got to sell, right? But who's going to buy that unit knowing there's a $400,000 assessment coming?
Yeah.
You can't unload it. So what do you do?
That's another tangled mess that we're dealing with here in real estate.
Yeah. I think that there should have been a lot more financial assistance from the state in helping the condominium associations bridge this gap while they got up to speed and got fully funded. The other thing is, Citizens Insurance has taken over a large portion of these condominium policies because so many private carriers pulled out of the state. But then they put that law into place that in order to have a citizens policy, you have to also have a flood policy. So condo unit or condominium associations that might not have had to have had a flood policy before now are paying two policy premiums that they didn't have otherwise. So it's just a lot dumped onto them all at once. It's really impacting that market.
Yeah, it's like a snowball effect. You're getting hit by both sides, right? And it keeps on rolling down the hill, getting a little bit worse each time. The problem gets bigger and bigger, actually.
Yeah. And then when they
So,
have a claim after they're paying all of this money into insurance that then doesn't, if it doesn't pay out, then they're hiring me and having to pay a portion of what they need to fix their building towards their attorney and then having to assess some more for that gap in insurance.
well, with all these changes, which are really impacting your clients, what have you done differently, if anything, in your negotiation tactics when trying to resolve some of these types of claims?
Yeah, I mean, on my end, you have to really leverage the potential bad faith exposure. That's the only place that you can get potential attorney's fees, that and a proposal for settlement. I try in all of my cases now, if there's no fee statute, if it's post change in the fee statute, to try to get a proposal for settlement out there so that if we're winning and beating that by 25% at trial, then we can recover attorney's fees that way. And then that helps us in leveraging our negotiations. Problem is, your client has to be willing to make an offer that's 25% less than what you think you can get in front of a jury. And then if the insurance company accepts it, then they're stuck paying your fees and costs out of what would be only 75% of what they need to do the work. So it's kind of a catch-22. But at the end of the day, most of my clients understand that that's the only way to make them whole, is to take that gamble up front to try to make a larger recovery for them on the back end.
Without getting bad faith, though, let's just go down that first scenario you mentioned with the, say, early proposal for settlement. Are your clients actually being made whole, though?
No, never. And that's the unfortunate reality that I have to talk to my clients about every day is if you want vindication, if you want some sort of public platform, we can go to Target and you can go to 6 random strangers in Target and I can tell them about your case and they're going to agree with us. And that's what you would get in front of a jury. You can get a jury to agree with you. But what I can settle your case for now while the fees and costs are lower versus taking it all the way to a trial at a higher fee rate and incurring all of these additional costs, you're going to net less. So if you're really just looking for validation as opposed to getting money to repair your building, then let's go. I'll find 6 random strangers that we can go talk to and you can get that validation. But my goal is always to get my clients as much as I can possibly get them to fix their home or fix their business. And a lot of times now, because there is no fee statute, that is an early resolution before things get out of control.
So you find that being proactive and really trying to find an early resolution is one of the best ways to navigate these new waters.
Yeah, if possible. And I'm not talking fire sale. I mean, it has to be a reasonable early resolution that makes sense, but you have to balance, the time in going forward and the costs in going forward and what the net outcome is going to be. Because the worst possible scenario is to backslide. If I could have gotten my client something 6 months ago where their net in their pocket was X amount, and then we get to a trial and we've spent so much building up this case that their net's going to be less than what I could have gotten them 6 months ago, that's a loss. Even if we win, that's a loss. And
For
so
everybody.
those are conversations that I'm having with my client very early on in the process.
And what about the client who walks in, and I'm sure you've seen this, and they have a number in their head for whatever reason, right? And, whether it's a public adjuster's estimate, it's a contractor's estimate, it's Bob the neighbor that told them that's what their case is worth, right? And that really isn't the number, at least in your mind. It's not a realistic number. How do you manage that conversation?
Sure. It's a conversation that I am having with my clients very early on in the process, especially now with everybody having access to AI. Everybody thinks that they have a great bad faith claim that they're going to win $1 million in bad faith punitive type damages. And so I'll sit down with my clients and walk through the estimate. Okay, this is, what you're looking at for your roof. This is probably what it's going to need to do your interiors. These are things in the estimate that are probably going to get eliminated in a motion in limine before we even get to a jury, to try to set expectations early on what they're really going to need to do the work. And also, we're having conversations usually in advance of the mediation is when I'm best poised to have that conversation, after there's been a little bit of discovery and we know the things that we're kind of on shaky ground with. We know the stuff that we feel confident that we're going to win on. And I'm doing that analysis of, okay, here's the things that we're likely to recover in front of a jury. And here's where your costs are likely to be by the time we get there. And then from this, your public adjuster's fee is going to come out of that. There's no way I can recover that from a jury or from a judge. And here's what would be in your pocket on what's likely to be your best day. And here's what's possible on your worst day. And here's what's likely to be the in-between number. So that they are having the full menu of how things could go at a trial before they're making settlement decisions on a mediation. I think it's really important to manage those expectations right up front, because if you let them run too long with that pie in the sky number that they have in their head, it only, the longer that sits there, the harder it gets for you to get it resolved.
For sure. And how does negotiating a condo claim, so with a board, differ from, say, a single family home? Any differences you see there?
The negotiation of it, I don't think is all that different. You're just managing a lot more personalities.
Mhm.
Any board of people, you get a lot of different characters. So you got to make sure that you're communicating constantly and that everybody is on the same page, because they have to be able to then go back and communicate that decision with all of their unit owners. So you have to make sure that you're educating them in a way that they can communicate that back. And not everybody is always going to be on the same page. So you're doing a lot of noticing closed board meetings so that you can go over everything every step of the way. A lot of Zoom meetings face to face so that they understand and are comfortable with every step in the process. Earlier on in my career, I would focus my communication primarily on the president of a condo association. And that's still true. Most of it trickles down through the president, but I have gotten a lot better about making sure that I'm looping in the full board on everything and not assuming that the president or the property manager is doing that for me,
Mhm.
because I've learned that that's not always the case.
Oops. All right. Well, let's pivot over to the windstorm insurance conference. So you've been there quite a bit. And what does sharing a panel with some of your opposing counsel teach you about how to negotiate with them maybe during the rest of the year? You learned anything new there?
I think that there is so much value in not only hearing the other side's perspective, value to your client. That way I can prep my client and prep my case for what I expect to be coming. If you're not hearing that other side, you're going to be surprised by it. But I'm not surprised by it because I'm hearing it discussed at all of these different conferences, particularly the WIN conference. But also in this age where we're doing everything by Zoom now, and we're
Mhm.
having Zoom depositions and Zoom mediations, I'm not interacting with the defense attorneys in the same way that I used to. So having a conference where I'm seeing them face to face really helps personalize those interactions. So for instance, there were 3 different defense attorneys at this year's conference that I have had cases with in the past, and made it a point to go up to them at the conference and say, hey, just wanted to introduce myself in person. Just, in case we have another case together down the road, so you could put a face to the name. And it's a lot harder to be short or snippy with someone or be curt if you've met them face to face and you've shaken their hand, people approach you different. And I think that that is one of the many benefits of being involved in a conference like the Windstorm Conference.
Yeah, excellent advice. I think everybody should take advantage of that because the the field is too small, right? What
Yeah.
and the pond that we swim in is very small, and you're gonna run into a lot of these same fish down the road, so no need to burn bridges, right?
Yeah, exactly. Mm.
So, Kelly, every lawyer I talk to has a case or at least some moment that has changed how they approach their work. I'd love to hear about yours. So, tell me about maybe a case or some turning point early in your career that really shaped the kind of advocate you are today. Can you think of one?
I can. I think pretty early on when I switched sides from defense to plaintiff's work, there was one particular woman who came to me after consulting with maybe 3 or 4 different attorneys. And I was still having a little bit of imposter syndrome at the time. I thought I wasn't really sure I knew what I was doing over here on the plaintiff's side and how to make this work. And what had happened, she had a major water loss at her property and she reported it to her insurance company. And they sent out a restoration company who ripped out her bathroom and her kitchen. And then the adjuster on the file looked at her policy and said, "Oh, actually, you have a $10,000 water limit. Never mind," and pulled the contractor out and paid the $10,000 water limit and said, "Bye." And this poor woman was living with her parents. I think her in-laws may have also been living with her 2 small children, and they just left her without a kitchen or a bathroom. And she had
Mm,
consulted with 3 or 4 different attorneys who said, "Well, you have a $10,000 water limit. There's nothing further we can do to help you." And what ultimately I was able to argue for her was that by sending out that mitigation contractor, they had constructively invoked their managed repair program. And pursuant to the Drew versus auto owners case, that was a new contract under which her sublimit for $10,000 didn't apply. Once they invoked their managed repair, they had to go in and return her property to its pre-loss condition, and they had failed to do that, so they breached that Drew contract. And it worked. And that was the
right.
first case I tried that argument on. I have used that in several other cases since, but it was a turning point for me as far as my confidence level in handling these types of cases because it was an argument that 3 or 4 other attorneys before me had missed, and they
Yeah.
didn't make it. And I was able to get this woman enough money to put her kitchen back together, put her bathroom back together, and move on with her life. And she was very, very grateful, and I felt very fulfilled in being able to help her do that.
Yeah. Well, I think that's the whole key to advocacy. You found a way. So excellent. A good result for her. I can't imagine being left without a kitchen or a bathroom and having children in the home.
Yeah, and she'd been
Um,
living like that for months with no help.
and I would assume that before that happened, it was somewhat functional before, correct?
Entirely functional.
And then they removed it.
Yeah.
That probably made your argument a little bit easier.
She had a kitchen sink set up in her lanai, that they were washing dishes in and stuff because they didn't have, they put a mini fridge out back. They had, I think, a porta potty set up because they was one bathroom and it was just horrible, horrific living circumstances. And I remember they took her EUO, I think, pretty early on in the process. And after the defense, we did it in my office. This was pre-COVID, so we were still doing in-person things. And after the defense attorney left, the court reporter was horrified at how this
Mm.
woman had been living. And I was like, "I need you on my jury. I need a whole bunch of you on my jury, and I'm going to make this win. We're going to win."
Okay,
Luckily, it didn't need to go that far. We were able to get it resolved.
good. Well, this next segment is what I call the mediation toolbox. So I like to spend a few minutes asking guests what's in their toolbox for mediation. So when you walk into a mediation, what do you reach for? What are your best tips for mediation?
Sure. I think the most important part of mediation happens before you walk in. I talked about prepping your client and managing client expectations. I think that that's the most important thing right out of the gate. Not only managing their expectations, but understanding their expectations. I had a mediation last week, I think it was, and I had prepped the client with, this is how the process goes, and they're going to start out very low. Don't let that frustrate you. Here's where I expect the opening offers to be, and here's, how these moves will go, down to that level of detail of what to expect going into the mediation. And we got into it, and the clients after the first move looked at me and said, if you had not warned us about that, we would have gotten up and walked out. And if you're not setting that expectation before you walk into that room, you're coming from behind. Your client has to know what to expect before they get into that room. The other thing that I think is important before you get to a mediation is I always send out a pre-mediation report with all of my expert reports, with all of my photos. I like to cut and paste photos into the report. These are the ones that I'm going to be showing to the jury. So I'm showing them to you. And here's my demand, and here's how that's broken out. I send that all out as far ahead as I can, usually a week ahead of time. I would love to get it out sooner than that, but it's a lot of times you're getting the information in as you're leading up to mediation. But no defense attorney is going to be surprised by what my claim is and what is supporting my damages when they walk into a mediation with me. I think that's really important.
And you share that with the other side as well as the mediator?
Yes, every time. I send it to both. But you would be surprised how many times I walk into mediation and it's so obvious that the defense attorney has not even opened it. And I'm
Hmm.
having to resend it to them and resend them all my documents during the mediation because they haven't even opened it before. And that's frustrating because I'm putting in the hard work to make sure that I'm educating them and their clients ahead of time, and they're not even looking at it. But that's a whole nother point. I also love, and not everybody does, but I also love brackets during a mediation process. I think especially on ones where you're so far apart, brackets are so very helpful in not only bridging the gap, but in sending a message and receiving a message. I can tell I'm very specific about how I send my brackets in the hopes that they are reading a message that I am sending. And I read a lot into the brackets that I get back so that I can figure out pretty quickly if my clients and I are wasting our time or if maybe we're closer than we thought we were. And if we stick this out a little bit longer, we might be able to bridge that gap. I think brackets are really useful for that. I also really rely on my mediator more than maybe a lot of other people do. I definitely have strategy in how I negotiate a case, and I have opinions on how I think things should be negotiated, but I use mediators that I trust. And if I'm going to say, "Hey Patrick, here's what I'm thinking about and here's why." But you're the one in the other room. And so you
Mhm.
might know that move is not going to be received in the way that I think it's going to be received. And you might say, "Well, I hear you on that, but maybe we should do it this way." And it's something I hadn't considered before. I think that it's really important to defer to your mediator sometimes in those scenarios because you're not in that other room and they're seeing the interplay and the dynamics between the adjuster and the attorney in the other room. And that I think can be a really beneficial tool that people don't take advantage of as much as I think that they should.
Involving your mediator and maybe asking some questions.
Yeah, not just as a numbers carrier, but as a strategist in how to convey those numbers in a way that is going to get you to a positive outcome.
A negotiation coach.
Yes.
Yeah. Okay. Very good. Those are all excellent. So, this next segment is the top 3 tips for better negotiation outcomes. So, our previous was about mediation. Now it's negotiation in general, which is a little different. So, what would be your top 3 tips for better negotiation outcomes?
I mean, I think it's a lot the same. I don't like to I don't like to keep an ace up the sleeve. If I am to a point where you and I are discussing settlement and negotiating, I want you to know where I think my case is strong. And I am laying it all out there. And it's helpful to me if you're doing the same thing for me. If you think that there is a weakness in my case, tell me so that I can convey that to my client and we can have a better negotiation. But if you're holding something back that you think is going to be your ace up your sleeve at trial, but still trying to negotiate with me, you have to give me something to leverage with my clients. Otherwise, we're never going to get this done. If all I know are the good things about my case, I'm never going to convince them to take something less than their best day in court. And so for some reason, I think that there are some attorneys that hold on to that strategy of shock and awe at trial, which may work if you plan on going all the way to trial. But if you're engaging me in settlement negotiations and you want to try to get this resolved, then you need to tell me why I should settle this case.
So it's all about sharing information.
Exactly. Yeah, you're going to have to share it with me before trial anyways. We don't have trial by surprise in Florida. So you might as well share it with me now and still waiting until the deadline for expert disclosures or the deadline for exhibit lists or the exhibit exchange. If you know it now, share it now. And maybe this is one that we can get resolved now. I also like to have phone calls to talk about the settlement positions. I think a lot of times attorneys, when we're trying to negotiate on our own outside of the mediation process, get stuck in the email of my client will take this, my client counters you with that. And you're, moving back and forth $5,000 at a time, which, it has its benefits. But if you pick up the phone call or the phone and say, hey, I had a really difficult call with my client. I'm having a hard time getting them much lower than where they're at. I don't really have a lot of room for movement. So I want to apologize about these $2,000 moves or $5,000 moves. I just don't have the room for that. And you preface what that negotiation is up front. I think that it prevents people from getting stuck on looking at just the numbers. If they really feel from you, hey, I'm trying hard here. I'm really working with my client to get this resolved, but they feel very strongly about this, or they really need X amount to get the work done. They run all the numbers. If you're having that conversation and developing that relationship with whoever's on the other side, I think it makes it a lot easier and more palatable to try to reach a resolution.
So you're providing context and additional information with your numbers,
Yes.
supporting. They're not arbitrary numbers.
Yes.
Makes sense?
Yes.
Okay, wonderful. And number 3?
Was that not 3?
Oh, two.
That's all I
Third
can
one.
think of. I always think that it is on my side of what I deal with. I do try to humanize it as much as
Okay.
possible. These are real people with homes, with businesses that are just trying to, they're not, despite what the insurance company may or may not think, have had one client in my entire time of handling plaintiff's work that I thought was really trying to defraud the insurance company and ended up having to withdraw. But my clients, 99% of the time, are genuinely just, they want to fix their house and they want to fix their business and they want to move on with their life. And so if you can humanize that side of it to the defense attorney so that they can humanize it to their own client, I think that that goes a long way. And I think particularly in a mediation context, I know we're talking outside of mediation now, but in a mediation context, if you can acknowledge the humanity on the insurance side as well, I do think that that is helpful. A lot of times when we were mediating after Hurricane Ian in particular, hurricanes back to back, Helene and Milton, where the insurance companies were dealing with a chaos as well. Acknowledging that in the negotiations and saying, hey, I know that you were swamped and you were dealing with 100 claims in a week, but this one slipped through the cracks. So let's do right by these homeowners now and get this one back to where it needs to be. Taking that approach as opposed to the you did this wrong and you did that wrong. And it puts people on the defensive. And once they're on the defensive, they're not listening to what you're saying anymore. They are thinking of how they're going to rebut what you're saying. But if you
Exactly.
start by acknowledging the humanity of it and being kind, they're more willing to receive and listen to what you're saying as opposed to just trying to figure out a way to rebut it. And I think that that goes a long way in negotiations as well.
That's excellent. That I think is a key. The communication, you can say the same thing, but if you say it in different ways, it has different reactions. And that's really one of the keys, I think, to negotiation too. And you hit on it.
Yeah.
Perfect. So here's a bonus question that I thought might be interesting for you. What's a book, whether it's legal or not, that perhaps shaped how you think about advocacy or negotiation? Is there any little tidbit that you were reading and was like, hey, wow, this is really cool. I'm going to apply this?
Gosh, a year ago, 2 years ago, the first party property team in my office started a book club where
Mhm.
we were reading a lot of self-help, mental health type books. One of the books we read was a book called Surrounded by Idiots. And the name of the book is somewhat misleading because it actually has nothing to do with idiots, but it's a personality analysis book. It assigns everybody has some pattern of color for their personality types. Red is people who are kind of aggressive in their dealings. They want to get things done right now. They always have to feel productive. Blue is people who are information based. They have to have all the facts before they can make a single decision, and they have to, have the charts and compare all the things. And so they can sometimes be slow to make a decision. Yellow is people who are more focused on being kind of the social butterfly, the life of the party. They get energized by being in social settings. And green are people that need to know the exact plan, they don't want to be the center of attention. They want to kind of sit back and you know, live a, kind of more basic life in their comfort zone. It's obviously more complex than that, and everybody's some combination of different colors. But
Mhm.
having an understanding of my own personality type after reading that book, I immediately jumped out. I'm a green. I like to live in my comfort zone. I like to always have a plan. I like my lists. And I read the book, and my husband is a red. He's very red. He needs to always be working and doing something and being production. And I'm like, can we rest? Can I just rest a little bit? But I think that you can use that in identifying personality types in everybody you deal with, in your clients, in your opposing attorneys, in your judge, in your jurors. It talks about how to identify it fairly quickly so that you can tailor your interaction with that person to a way that makes sense to them. And I think that that's been beneficial for me in just dealing with people in life in general.
Fantastic. I love it. That's like the art of psychology right there.
Yeah. Read it. It's a
Yeah.
good one.
Very good. Well, Kelly, thank you so much for coming on the show. This was a great conversation. I've got a feeling that listeners are going to probably want to figure out how to reach out and find you. So, where's the best place for people to learn more about you and your work or to reach out?
They can find us at stockhamlawgroup.com. They can reach me at kfantetti@stockhamlawgroup.com by email. I'm on LinkedIn. I'm on Facebook. Uh, all of the normal social media. You can reach me at the office, 813-867-4454.
Awesome. Well, thank you so much. And if you enjoyed this episode, please hit follow on Spotify, Apple Podcast, or wherever you listen. And if you're watching on YouTube, subscribe, drop a comment. Thank you so much, and we'll see you on the next episode.
Thank you, Patrick.
We hope you enjoyed this episode of the Meaningful Mediation Podcast. If you did, be sure to like, subscribe, and comment. Additional episodes can be found on YouTube and your favorite podcast channels. Until next time, less dispute, more resolution.